Yes, please take count for the protect form was still 10.
Is it anything you're not supposed to have? Go ahead and unlock that.
Is this the information you needed? Yes. Hand it to me slowly. Now keep your hands where I can see them.
Turn the engine off, hands on the wheel. Is there anything in here you're not supposed to have? Go ahead and unlock that phone for me. Most people don't realize they just stepped onto a tripwire. By the end of this video, you'll know the one sentence that legally stops that demand cold, and why it works, even when your heart is pounding through your shirt. Let me walk you through a traffic stop. The kind that happens 10,000 times a night in this country. The dashcam clock reads 11:14 p.m. The officer is young, a little too chatty. The driver, we'll call him Marcus, hasn't been speeding. His taglight is out. That's it. That's the whole reason. The blue lights came on. But before Marcus even hands over his license, the officer asks a second question. Any chance you have a little weed in the car tonight? Maybe a roach in the ashtray? Marcus, nervous, shakes his head. No, sir. The officer nods, but then he looks at the phone mounted on the dash. Mind if I take a quick look at your phone, just to make sure nothing illegal is going on? And this is where the myth butts up against reality. A lot of people think, well, if I refuse, it makes me look guilty. Maybe they can just force me. Others believe they need a warrant to touch my phone, so I'm safe no matter what. Neither belief is quite right, and both will get you into trouble if you don't understand the trap that's being set. The first myth we have to dismantle is the idea that police can freely force you to unlock your phone. They can't, at least not in the way most people imagine. The act of pulling a passcode out of your head is fundamentally different from handing over a set of car keys. It's not a physical object. It's the content of your mind. And the Fifth Amendment says the government can't compel you to be a witness against yourself. Your passcode is testimonial. When you say the passcode is 2589, or when you type it in, you're communicating something you know. That's the heart of the privilege against self-incrimination. In the 2019 case Commonwealth v. Jones, the Massachusetts Supreme Judicial Court looked at this exact problem. Law enforcement wanted to compel a defendant to enter the passcode into his phone. The court said no. Forcing a person to reveal the contents of his own mind is the very evil the Fifth Amendment was designed to prevent. That's not an obscure interpretation. It's bedrock constitutional law. But here's where the myth splits. If Marcus had been using his thumbprint or his face to unlock that phone, the story changes. A fingerprint isn't testimony. Neither is the geometry of your face. They're physical characteristics, the same way a blood sample or a handwriting exemplar is physical, not communicative. The landmark case on this issue is Commonwealth v. Bost out of Virginia. The court there held that while a passcode is the content of the mind and therefore protected, a fingerprint is not, and police could legally force the defendant to press his finger onto the phone. But since then, multiple federal courts have taken the same position. So the second myth that biometrics give you the same legal shield crumbles the moment an officer says, "Just use your thumb." Let's go back to the body cam. The officer is still standing by Marcus's window. Marcus, who unlocks his phone with his face, doesn't know any of this. He's seen enough cop shows to think, if I don't cooperate, they'll get a warrant, rip my car apart, and it'll be worse. So he picks up the phone, glances at it, the screen unlocks, and he hands it over. And watch the footage carefully. That moment right there is the pivot. The second the screen lights up, Marcus has done three things he can't undo. He's surrendered his entire digital life, texts, photos, location history, banking apps, private conversations, without a warrant. He's voluntarily given up his Fifth Amendment protection by performing the testimonial act of presenting a ready-to-search device. And he's given the government what courts call consent by conduct. Even though he never said the words, his actions made the search look consensual. A defense lawyer later will have a steep hill to climb trying to get that evidence thrown out. Now let me pause the imaginary footage and tell you the three mistakes hiding inside those 30 seconds, because If you strip away the adrenaline, they're razor sharp. Mistake number 1, answering the small talk question when the officer asked, "Anything in the car you shouldn't have?" The legally safest answer isn't yes or no. Both create a verbal record. The yes incriminates you. The no can later be used to accuse you of lying if something is found. The only thing you're required to provide is your license registration and proof of insurance. That's it. The Supreme Court made it clear in Berkemer v. McCarty that a traffic stop is a seizure under the Fourth Amendment, but it's a brief one, and you're not obligated to assist the officer's investigation beyond identifying yourself. Mistake number 2, believing that a warrant is required before the officer can even ask to search your phone. The Fourth Amendment, as interpreted in Riley v. California, says the police generally need a warrant to search the data on your cell phone. But Riley doesn't mean an officer can't ask you to hand it over voluntarily. Consent is an exception to the warrant requirement, and consent can be verbal. Or, as Marcus discovered, behavioral time. The moment he unlocked the phone and passed it across the seat, and he gave the functional equivalent of consent. No warrant was ever needed because Marcus himself opened the door. He had to do something to prove he wasn't hiding anything. That's the psychological pressure every officer is trained to leverage. They'll phrase a demand as a request. They'll frame compliance as the marks of an innocent person. But innocence never required you to surrender the most private device you own. Now, this is the part of every one of these videos where I give you the exact words to say, not a law review paragraph, not a speech you'll fumble under pressure, just a short, calm phrase you can repeat even if your voice shakes. I'm going to exercise my right to remain silent. I'm going to exercise my right to remain silent. I'm not going to unlock my phone. That's it. You'll notice I didn't tell you to scream. I don't consent to a search. Those words, as powerful as they are not the only tool in the box. What you're doing in that moment is specifically invoking your Fifth Amendment privilege. You're making it crystal clear that any act of unlocking typing or speaking your passcode would be compelled testimony, and you're refusing to give it. You're also not saying, "I won't talk to you." You're framing it as a right you're choosing to exercise, which changes the entire legal landscape. The second a court looks back, "I'm going to exercise my right to remain silent," anchors the stop. It tells the officer and any judge who watches the video later that what followed was not mutual agreement. It was an invocation. Now you might be thinking, what if the officer says, "Fine, but I'm taking the phone home." Anyway, they may try, they may even do it. That's when property seizure becomes the next fight. If they grab the phone from your hand or the dashboard mount, that's a separate Fourth Amendment event. A seizure of your property without a warrant. At that point, your words shift to, "I don't consent to you taking my property, and I want a lawyer that combination property objection plus Sixth Amendment counsel invocation builds a second wall." Is the simple, unshakable assertion of your right to remain silent. Let's put a real face on this. Drawing from a composite of traffic stops I've seen play out in court, there was a case where a driver was pulled over for a rolling stop. The officer smelled nothing, saw nothing, but the driver was shaking. That nervousness, the officer later testified, gave him a hunch. He asked to see the driver's phone. The driver handed it over, unlocked. Inside, the officer found text messages that suggested a drug transaction days earlier. That phone was the only piece of evidence that led to a felony charge. The driver's lawyer fought to suppress the phone search, arguing there was no warrant, no consent, no probable cause. The judge watched the body cam video. The judge saw the driver unlock the phone and hand it over without a word. The judge ruled it was voluntary. The case moved forward. The lesson: a warrant is not a magic shield if you voluntarily disarm yourself. Now let's talk biometrics again, because this is where the practical, actionable guidance matters. If your phone unlocks with your face or fingerprint, law enforcement can, under current precedent in many states, legally force you to press your thumb onto the sensor or hold the phone to your face. They can't make you tell them the passcode, but they can physically use your body as a key. This distinction is infuriatingly delicate, and it's one of the fastest-moving areas of Fourth and Fifth Amendment law. Some state courts, like in Indiana and New Jersey, have pushed back and held that biometrics are still testimonial in certain contexts. But across most of the country right now, the safe assumption is this: if you want to protect the contents of your phone, turn off biometric unlock before you ever get pulled over. I'm not giving you advice to hide evidence. I'm giving you advice on how to make sure your constitutional rights actually function in the real world. Disable Face ID, disable fingerprint, unlock, and rely on a strong alphanumeric passcode. Then your phone doesn't become a key that an officer can grab and use against you. It becomes a locked safe, protected by the privilege against self-incrimination until a judge signs a warrant. Let me connect these dots with one more piece of case law. After Riley v. California, the Supreme Court recognized that cell phones are not just containers, they are mini-computers that hold the privacies of life. The police need a warrant to search the data on the phone. But Riley didn't address compelled unlocking and it didn't erase the consent exception. That means the moment you unlock the device, even silently, you are arguably stepping outside the protection Riley gave you. That's why invoking your right to remain silent is so effective. You're refusing to take the very step that would strip away the warrant requirement. You're keeping the locked gate closed. Now, what about the officer who says, "Fine, sit tight, I'm getting a warrant"? First, understand, that's not a threat. It's the system working the way it's supposed to. A warrant requires an officer to write down under oath exactly what crime they believe was committed and exactly what evidence they think is on that phone. A neutral magistrate then has to agree there's probable cause. That takes time, and it imposes an external check on police power. Even if they get the warrant, your silence hasn't hurt you. It's preserved your ability to challenge the warrant later to argue it was overbroad or that the affidavit was insufficient. You haven't handed them a confession. You haven't opened a window they can exploit. You've simply held your constitutional ground. And if they get the warrant and still can't crack the passcode, that's another legal cliff. Courts are currently divided on whether someone can be held in contempt for refusing to unlock a phone after a warrant has been issued. The government can argue that a warrant overrides the Fifth Amendment. But strong counterarguments exist under the foregone conclusion doctrine from United States v. Hubble and later cases. That's a different video. For tonight, what you need to know is that refusing to unlock until a lawyer is present changes the entire power dynamic. You go from being a source of evidence to a person who knows their rights. Rights holder. We're watching the tail end of the dash cam now. In our scenario, after Marcus handed the phone over, the officer spent 15 minutes scrolling through messages, photos, and location pins. He parsapram one. He didn't find a drug deal, but he found a heated argument in a text thread that gave him just enough to call in a K9 unit. The dog didn't alert, and Marcus was eventually let go with a warning for the tag light. But the phone, it was copied. The data was downloaded. A file was created. Marcus may never know that a record of his private conversations now sits in a department server. That's the quiet cost of not knowing the words. Here's what I want to leave with you. Your phone isn't just a gadget. It's a diary, a bank vault, a Rolodex of everyone you love, and a map of everywhere you've been. The law for now says you have a right to keep it locked, but rights are verbs, not nouns. They only work when you exercise them out loud. The next time you see flashing lights in the rear view, the most powerful thing you can do, long before you reach for your wallet, is to mentally rehearse, I'm going to exercise my right to remain silent. I'm not going to unlock my phone. But what happens when you're not even driving? When you're just walking down the street with that phone in your pocket and an officer stops you with no car, no windshield, no dashboard camera between you? Next time we're going to take that scenario apart and talk about the one move people make on foot that destroys their entire defense before they even realize they're being investigated.